Good afternoon and welcome. I'm delighted to have you here and welcome you for this inaugural session of a new webinar series entitled The ICDR Rules in Practice. Over the next month, you will gain insights into how the ICDR rules work in practice, so make sure you keep tuning in. Today's topic is getting it right from the start, best practices for arbitration clauses. We chose this topic because any arbitration, and that includes ICDR matters, must start with the parties' agreement to arbitrate. It is already at this stage that you can get a lot right, or of course, wrong if you don't do it the right way. I have the pleasure today of welcoming three speakers and guiding this discussion through the session. In practice, when it comes to the arbitration agreement, you have two options. You can draft your own clause, or you rely on the clause designed by institutions. The ICDR stands out here because it offers a dispute resolution clause builder for arbitration and mediation proceedings. Put simply, you can tell the clause builder on the ICDR's website what you want, and it will automatically come up with a tailor-made solution for you, a tailor-made clause for you, which you can again copy and paste. This is perfected to suit your needs, and there are no issues because it has been designed by the ICDR. You can find a link to that in the chat if you're interested, but please do check it out only after the session and stay with us for now. Where you do see issues in practice is not with the clause builder, but quite regularly when parties draft their own clauses. And this includes multi-tiered arbitration clauses, where the dispute resolution process includes certain steps before the arbitration can be commenced, such as negotiation, mediation, and then arbitration. But this is just one way to structure a multi-tiered clause, as Mino, our first speaker, will highlight. Mino, you are a partner with Peter and Kim, and you work out of Seoul, Korea, but will be based in Singapore very soon, I understand. What are your views on these multi-tiered clauses? What can we get right? What can we get wrong?
Thank you, Harald, for the nice introduction. I think multi-tiered dispute resolution clauses are nice on paper, in theory, but when they actually applied, there are things to consider. I will give you an example from a construction disputes context, if I may, because I do a lot of construction disputes. You see a lot of standard multi-tiered dispute resolution clauses in which parties have to, it's not a choice, they have to go through mediation first. And then after they've done a certain period of mediation, tried it hasn't worked, then do another round of CEO negotiation. And if that hasn't worked, then go to arbitration. Or for people who are familiar with the FIDIC standard terms, it says that you go through a DAAB procedure. Once that has been tried out but hasn't worked, then you have a cooling off period. It's a bit like a divorce, and there's a bit of a cool off period. I haven't been through one yet, but and then only then you are able or you're allowed to go through arbitration. The theory underlying these clauses is if it goes well, then parties are invited, or there's a structure to have a sit down and talk, which allows the parties to settle the dispute and resolve the dispute without having to spend too much money on the lawyers and going through arbitration and so on. The good intention there. The problem is the if element in reality, in my view, especially in construction disputes, is not often as the parties wish it to be for two reasons. One, construction disputes timing-wise arise most often at the very tail end of a project. Because if you think of a project, the contractor is building something, and while doing so is achieving milestones and getting milestone payments from the employer. And both parties are motivated to keep the project running. Contractor wants to get money, the employer wants to get the project done. And so they keep on continuing the project until the very final milestone payment, when all the delay issues, the prolongation cost claims, the retention claims, whatever, is piled up. And so at that point in time, the sit-down effect diminishes. This is already almost done, and the contractor wants to get the claims sorted, get them sorted quickly, efficiently, and there is already a big gap identified, and sitting down for 2 months doesn't really help. And so there is this timing issue. Number two, I think there is also a cultural element, because sitting down and talk, in my experience, often requires the parties to have a similar cultural vibe going on so that they can really sit down and talk. Say, if you're in a mediation in England, you have an English contractor and an English employer, or the same cultural background, you can sit down, you speak the same language, not only literally, but also in a wider context, the industry language, you can converse very well. Whereas in an international context, that's not always the case. Sometimes there are parties who like to be non-confrontational, be quiet, and like to rather like to get guidance from an arbitral tribunal, the wise people in the panel. And so this sitting down concept can or cannot work, and I'm more in favor of having that built in a more flexible way, rather than have that as a mandatory step in the contract. I'll pause here. Multi-tiered dispute resolution clauses, good in theory, but in practice, a few wrinkles to think about.
Thank you very much, Mino. A lot of takeaways, in addition to you hopefully never going through a divorce. You mentioned one very important point here that applies in many international settings, that was culture. If we have a domestic arbitration, it will usually play less of a role, although company culture, of course, comes in. But when there is an international arbitration, let's say between one party from Asia and another party from the Western world, or from any other part of the world, of course, culture plays a crucial role, and this has also an impact on how disputes get resolved. And this brings me to our next speaker, Christine. Christine, you are a partner at Hughes Hubbard & Reed, working out of New York and Beijing. So a lot of culture we have with us today, as you will note from the introductions. And there is one more to come, where we again have two countries. Christine, what is your view on multi-tiered clauses, including on the cultural aspect, but also in general?
Thank you, Harald. I agree with Mino on many points he just pointed out. Multi-tier clause is commonly used because it allows various tools and options for the resolution of dispute, and also it promote the resolution prior to kind of expensive arbitration procedure. So it's a good design, and it's a good clause. But when we use that, we really need to consider the specific disputes before us and whether it's necessary in the first place. Really, it depends on the specific disputes, especially for the cross-border international disputes. For example, if it's just a loan agreement disputes, and the other sides did not challenge, did not, the debt, but it's just does not want to pay, and whether mediation or negotiation can be very useful if you take a long time to do that. I just want to briefly mention 3 points. And the first thing, in practice, especially in the cross-border disputes, you really need to look at the multi-tier dispute clause to see whether it is sufficiently clear and specific. Number one, to avoid being overly burdensome when you come to that. And number two, to avoid the delay. For example, in practice, if you set up a very complicated appointment mechanism or very strict qualification requirement for choosing the expert to conduct mediation, that may take a long time and the party cannot reach agreement. And also if you do not have a specific time period for each tier and the other party or the party who do not want to move faster, they can cause a lot of delay in that process. And number two, I want to mention is the tier 2 mediation. Mino mentioned that that's usually the multi-tier clause. We have negotiation, mediation, and arbitration. But I would want to say, really, the mediation, you need to look at it with an open mind and whether it's mature, it's a right timing to do that. And the mediation cannot only limit it to that pre-arbitration stage, because AAA-ICDR has very successful mediation structure. For example, Article 4, you can do that at administrative conference, and Article 6, you can do a parallel mediation when you have arbitration procedure ongoing. And also Article 35, and you can do a consent award, anytime when you mature to reach an agreement. The last risk I want to mention is if you have a multi-tier clause and if there's a failure to fulfill that pre-arbitration condition. And I know at least in China, there are some cases where the party, they lost the arbitration and then they went to the court to challenge the jurisdiction and to set aside award. And some cases was even supported by local court because they think there's a failure to fulfill the pre-arbitration condition and the tribunal has gone all the way to come to a final award. But I don't think that's right because it's a admissibility. It's not a basis for challenge. I think most jurisdiction accept that, but that's really a risk, especially when you may need to enforce that in China.
Thank you so much, Christine. Also from you, a ton of insights, a lot of points to digest. And as was the case with Mino's points, I believe for every single one of those, we could have a webinar on our own because there are so many points to discuss. We do not have time for that. Today, we only scratch at the surface, so to say, while still giving you a lot of hints, tips, and tricks. And this leads me to our third speaker, last but certainly not least. Sherina, you are a partner at Stewart's working out of London, but you also do a lot of India-related work. So again, the cultural element here really plays a lot of importance, or at least you combine more than one culture in you and in your work. What is your takeaway from what Mino and Christine said so far? And generally, what is your experience with multi-tiered clauses?
Thank you, Harald. Multi-tiered clauses, I think, are helpful and are widely used in cross-border contracts. And whilst these clauses are designed to provide structure to the dispute and the dispute resolution pathway, the effectiveness actually hinges on something that Mino said, and which is often overlooked, which is the background and the culture of the parties. And different jurisdictions have varying attitudes towards multi-tiered clauses in ADR. Parties sometimes from civil jurisdictions, for instance, may view arbitration as an extension of court litigation and prefer detailed procedural requirements and pre-arbitration steps. But in contrast, common law jurisdictions like India, like the UK, often favor flexibility and may be more comfortable with less formal, good faith negotiation clauses. So understanding these perspectives is actually really crucial when drafting your escalation mechanism to ensure, one, that it's both enforceable, a point that that Christine just brought up, and that it's effective. The willingness of the parties to engage in negotiation or mediation also depends on cultural and business norms. So one would see that in some Asian and Middle East jurisdictions, face-to-face negotiations and mediation is deeply embedded in business culture, making pre-arbitration settlement attempts more meaningful. But conversely, parties from adversarial legal traditions may see mediation as a mere formality and just, something formal, rather than a genuine step towards resolution. So tailoring the clause to reflect these differences ensures that mandatory negotiation or mediation requirements are taken seriously rather than just treated as a procedural hurdle. Another thing that Christine said, which was very accurate, was about timelines. And cultural factors also influence expectations regarding timelines. So some jurisdictions emphasize a rapid dispute resolution process, whilst others accept that there will be protracted negotiations, and that's just part of doing business. So I think it's important for a well-drafted multi-tiered clause to take into account timelines for each step so that what you have is not long drawn out or taken advantage of. For me, the biggest benefit of including these clauses is frankly and practically to save the egos of the parties getting in the way at the time the dispute has happened. So if the mechanism is to try to settle the matter and it's embedded in the contract, then there's no feeling that either party's ego is bruised on who's going to bend first and who's not. And I just have a war story on that, because I was representing a client from India and given them advice that they didn't actually have a very good case, and they should settle. And they refused. And and we didn't have a multi-tiered clause factored into that contract. And it was a point of ego. I will not bend first. It should be the other side. And they're like, well, you don't have a very good case. Why do you want to get into an arbitration when you don't have a very good case? But it was an ego point. And it was actually the other side who approached me. And we then found out that the other side had a funder as well. So it's like, well, if they've got a funder, the funders effectively told them what I've told you. So you should try to settle it. And we did settle. But it was just that ego point that was getting in the way. So that's, so by tailoring the clause to account for all these factors, you can ensure the likelihood of compliance with pre-arbitration steps, reduce procedural disputes, and ultimately, I would think, facilitate a smoother resolution process.
Thank you so much, Sherina. Again, a lot to take away and many topics we could discuss on for hours. We don't have the time for that. But let me just briefly highlight to everyone the three takeaways that I took, really. I believe we learned that there is no one-size-fits-all approach. This depends on the industry. Mino highlighted the construction industry in particular from his main practice area, where there are different ways to resolve with the adjudication boards, which we see much less in other industries. It also depends on culture. Sherina, you pointed out the adversarial nature that is more common in some parts of the world than other parts of the world. And that, of course, has a huge influence. Or even said, egos may get in the way of finding a resolution, but then mediation, as you highlighted, may be much better suited than in other instances. And lastly, I wish to also not only speak about the positives, but highlight the dangers. And I believe Christine in particular gave a very good overview of the potential dangers with multi-tiered clauses. in particular when it comes to the timelines that may be involved. You know, if your clause says you first negotiate for 90 days, then you mediate for 90 days, you know, by the time you finally get to arbitration, you may have already forgotten what the dispute was about. So there are goods, there are bads. It really depends on the situation. And this is something to keep in mind already at the drafting stage, of course, because this is when we set the rules as regards dispute resolution clauses. A quick reminder to the audience, please. You are very welcome to put questions in the webinar chat. Please do so. We have helping hands in the background who will filter the questions, possibly answer some of them right away, or then refer those that this panel should address to us. Before we get to any questions, let me move on to a new topic. That new topic is arbitrators. Now, the old adage, I believe it is attributed to the late Pierre Lalive, is that arbitration is only as good as the arbitrator is. But whether we subscribe to that adage or not, I do believe that we can all agree that the appointment of an arbitrator is a crucial step in the arbitration and will have a major impact on the arbitration. Indeed, one of the major advantages of arbitration is that you can have recourse to a neutral panel rather than to a at least seemingly not so neutral panel if you go to a state court. Again, for the parties, we have at large two options that they have at their disposal. You can simply adopt the procedure that the institutional rules have set forth, or you design your own rules, your own requirements when it comes to arbitrators. Let me again very briefly highlight what the ICDR rules say. We have Article M4 of the mediation rules and Article 13 of the ICDR arbitration rules. And there is a list method. So the case manager, the ICDR case manager, will gather the party requirements on arbitrators or also mediators on the first administrative call. And what plays a role here really is expertise, experience, and qualifications. And the case manager then uses the AAA panelist search tool to find top picks of the 800 plus neutrals that the ICDR has on its panel. And the parties can then rank and strike. But this is really just to give you the background on the ICDR rules, and this is the standard. If it's the standard, there is little problems because this is in accordance with the rules, this is tested, no issue. But there is also the not so standard when the parties make changes already in the arbitration agreement. And this may include sometimes requirements for arbitrators, whatever these requirements are. This brings me to Christine. Could you please shed some light on this? What do the parties change based on your practice and your experience? And again, what are the do's? What are the don'ts?
Sure. Thank you, Harald. I cannot agree more when Harald mentioned arbitration is as good as the arbitrator you selected. So the first sentence I want to say for the parties, especially in my experience for Chinese party, Mino can speak for Korea and Sherina for India and Harald for Singapore, Malaysia. But so for some Chinese parties, if they think they had a weak case, sometimes they did not participate in the process of selection of arbitrator. That's really, I strongly recommend not to do that because, as I said, it's very important. And actually, the two major benefits of arbitration, number one, you can choose your judge, right? In the court procedure, you cannot do that. And number two, of course, the global enforcement. So that's your right and the benefits, and you must use that. And what kind of arbitrator you choose, you select, and that will impact the outcome of the arbitration. So so really important to join that process. With that said, I just want to mention briefly 3 points. And number one is the number of arbitrator. If you look at the model clause of arbitration institutions, they usually give parties the room, either to choose sole arbitrator or 3-member tribunal. Sole arbitrator has benefits. It's obvious. It's cost effective because 3-member panel, the cost may not be 3 times or beyond that. And also it can be more efficient because you don't need to coordinate the calendar, to find the available time and to deliberate, and people have different views and you need to deliberate again. So that's obvious. But again, if you look at the statistics, you still see probably over 50% of the cases where the 3-member tribunal were chosen. Why? Because it's, as we all know, for arbitration, you don't have an opportunity for appeal. And arbitrators are also human, and the human may have errors and mistakes. And with one sole arbitrator, you have 2 eyes to look at all this process to drive a award. But 3 arbitrators, you have 6. So that's reduce the risk of error and mistakes. And also the 3 arbitrators, they may come from different background. They have different expertise, like technical or that specific industry, or very experience in international arbitration. So all that is a contribution from different perspectives to make you have a better outcome. And of course, with 6 eyes and 3 person, you have greater neutrality and a balanced tribunal. So that's why. So that's really my advice would be, don't make too early the decision. When you draft your arbitration clause, you don't know what will happen in the future, just choose the sole. You can give yourself some flexibility and leave it there, leave it open so that you can, when time is closer, when disputes there, you can decide depending on the specific circumstances. So that's the number of arbitrator I want to talk. And the second, of course, as Mino mentioned, is very important, the culture background. When we talk about culture background of arbitrator, it's not just nationality. It's not just nationality. A neutral nationality of presiding arbitrator is far more complicated because especially for the international arbitration, the international nature requires cultural sensitivity and awareness to ensure a fair and balanced outcome by bridging the culture gaps. So, for example, for some arbitration, in my experience, my clients or the parties, or as an arbitrator, the parties is state-owned companies, SOEs. If you have a little bit culture background about SOEs, and it's very helpful in the entire process, not from procedure, but also from substance, to help better understand, to interpret the evidence, why is that, why the negotiation, that evidence, why is that way or not instead of the other way, because the decision-making process, the communication style, the business operation model of SOE may different from a Western company. So a lot of factors come into play, culture experiences and personal inclination. I don't know, whether you got experience, but sometimes you have people, they may not like SOE or kind of, not like one single country, and this happened too. So you need to check it out, and also the ability for the arbitrator to navigate this culture gap and the familiarity of the local industry. A lot of factors that's all under the big umbrella of country background, and you need to dig in together with your counsel. And the last point I want to mention is when we, sometimes the counsel try to put the criteria as detailed as possible for the appointment of arbitrator. That's good intent, but really may not be a good result. Less or more, you really need to be careful about that. In my experience, I was sitting as a co-arbitrator in a arbitration case under a European arbitration institution. And there's an arbitration agreement saying that the presiding arbitrator should be familiar with Dutch procedure law, qualified in New York, and practice in New York. So as a co-arbitrator, I work with another co-arbitrator for months on the appropriate presiding arbitrator, because the parties did not disagree. Whenever we come out with a proposal, they cannot reach agreement, whether because it's only qualified but never practiced in New York, all these kind of things. So it's hard to find a candidate. And eventually the institute proposed some candidates, and the parties not satisfied, and also take a long time to come out to make a decision on the presiding. And eventually it did not work out very well, because the presiding arbitrator may not have a lot of experience sitting as presiding. So how to organize deliberation and how to handle, the very complicated, sophisticated counsel, all these things, and the process was not very smooth and spent a lot of time and cost. So less or more is really a very important point you need to take into consider.
Thank you so much, Christine, especially for your war story. I believe those stories are often what we remember even months later. And that's often much better than generic advice. I think the Dutch practice in New York and being based in New York, that's very easy to remember. So thank you for that, and generally for your views. Sherine, prior to this webinar, we had a quick discussion, and I believe you also have some very interesting war stories to share on especially what one can do wrong when it comes to putting requirements for arbitrators.
Harold. Well, my mantra is very similar to Christine's. Keep it simple, keep it enforceable. So whilst parties sometimes try to ensure an optimal tribunal composition and add excessive complexity, what they don't understand is that they're actually creating unintended hurdles, which can lead to delays, procedural disputes, sometimes satellite litigation, and even the risk of an unenforceable clause. And something that Christine touched upon, which is when you're overly prescribing an arbitrator's requirement by saying that an arbitrator needs to have, say, a certain nationality or an industry expertise or a certain number of years under his or her belt of practice, it unnecessarily narrows the pool of arbitrators. And this creates a deadlock, particularly if the specified qualification does not align with the pool of arbitrators that is available, or if a certain aspect of the dispute arises which actually needs a totally different expertise. So, for example, I was approached to sit as an arbitrator where the clause had said that the arbitrator appointed needed to have certain cement expertise. Now, what is certain cement expertise? And so the parties were speaking to all and sundry to try and find out anyone who had cement expertise. And I said, well, it's a very generic term in the contract, but I don't know if I qualify to have that certain, does it mean that you've done one arbitration with cement expertise or two, or so? It really narrowed the pool, and it was wasting a lot of time for the parties to go and look for that right person. In fact, it's also common practice in India until recently to have a senior employee of a government-owned company to act as the arbitrator in disputes concerning the same company. It's also not unusual for parties in India to select arbitrators from a panel appointed by one party, which would include retired government officials. And that was until very recently. So, and such clauses just work contrary to the interests of the parties, as the appointed individual, that is agreed by the parties or by designation, may not actually have the adequate qualification to resolve the legal or factual query that is in front of him. So the more qualifications and the restrictions, the longer it's going to take to constitute the tribunal. And the worst fear of this is what I touched upon earlier, is satellite litigation on whether or not the candidate meets the qualification set out in the clause. And what does that lead to? It leads to increased costs. So in conclusion, I would think a well-drafted clause has to strike the right balance. It has to give enough structure to guide the process, but enough flexibility to adapt to the nuances of each dispute.
In the case you mentioned, Sherina, which I find fascinating, were you able to cement your position?
I declined because I
declined.
Because I just, what is, cement, how much is cement expertise? I'm not a cement expert, so I just thought I'd better ask. And it seemed like a purely commercial dispute. That was a bad thing.
Maybe the parties were expecting you to send in a picture of you with a shovel and cement, No, but I think thank you so much, Sherina. That's again an excellent war story that will stick. As I mentioned before, we discussed this prior to this webinar, and I've already told several people about it because it's a very funny example, but also very illustrative of what you can do wrong. Mino, this leads me to you because you have obviously cemented your position here as one of our speakers, to borrow your joke. We also discussed prior to this webinar, and you also have a very interesting problem to share that arises in practice when it comes to the limitation of the selection of arbitrators. But I will not say more. I hand over to you, Mino.
Thank you, Harald. I agree with Christine's observations and Sherina's comments. More might be less, less might be more. Quite often, corporate lawyers are in charge of negotiating and drafting the contract, including the dispute resolution clause, in which case parties are sometimes obsessed with expressing neutrality. Bargaining power is a big word, and you think, okay, for dispute resolution, you need to put in neutrality, one of which is nationality. Thing is, you need to think it through because, say, for instance, there's a contract between a Korean party and a non-Korean party, could be a US party, in a contract governed by Korean law. And the corporate lawyers think it's a smart thing to do to expressly say in the arbitration clause, none of the party nationalities should, the arbitrator, be it sole or be the presiding arbitration, shall not be from jurisdiction where the parties are coming from. And you think, okay, this sounds pretty neutral, it's very good. But then in reality, you would then need to find someone who is not Korean and not US, but has sufficient degree of experience and knowledge, say, in Korean law. And then you look at Japan, you look at Taiwan, there are a lot fewer people, a lot less people than you would like the pool to be. And so in reality, when applying that nationality neutrality problem, you look at Japan and the level of sophistication or the fitting arbitrators that you would like to have in your dispute, they may not have the industry experience. This might be very, very different from what you expect, which I think the corporate lawyers haven't thought through. The other permutation of this is Sometimes you exclude nationality and then come up with someone who is not a Korean and not a US national in that example, but who has been residing in Korea for 25 years and is sort of semi-Korean, just looking not Korean. And so sometimes the corporate lawyers haven't thought through the residence aspect of this. Long story short, overthinking this might lead to complications, unnecessary complications, and less is quite often more.
Thank you so much, Mino. That's again a wonderful story where you highlight that something that seems the right approach, as you said. Yeah, that makes sense. In reality, when you get to the dispute, you realize it's really not. It was really not the right thing to do. Before we move on, and before I sort of summarize with my takeaways, I'd like to highlight one additional point from the ICDR rules, if I may. We also discussed the number of arbitrators, and the default rule under the ICDR arbitration rules is a sole arbitrator, but the ICDR also has a streamlined panel option where you have a 3-member tribunal, but the presiding arbitrator essentially takes a more dominant role and in order to speed up things and makes procedural decisions up to the evidentiary stage. So this is really just to give you the background on the ICDR rules. Let me briefly summarize this last session with my takeaways. I believe what I learned is on the number of arbitrators. Christine highlighted that there is no opportunity for appeal, and that 3 arbitrators have 3 pairs of eyes, 6 eyes, not just 2 eyes. So there is less margin of error. But still, I believe we all all the 3 speakers highlighted some issues that may come when you set the number in advance. So it's a balancing act. This brings me to what Sherina said. She said it's necessary to strike the right balance, and you must always keep it simple and keep it enforceable. There is no point in setting forth numerous requirements for arbitrators, and then rather than doing the arbitration, you spend a month or even longer resolving satellite litigation. This causes a lot of costs and, of course, also leads to a lot of delays. And finally, Mino highlighted, and this goes out to all those who are drafting arbitration agreements, please do discuss them with arbitration practitioners, and this goes to the corporate counsel who draft the arbitration agreements. Sometimes what really makes sense, Mino highlighted, there is a US party, there is a Korean party, so let's make sure that none of the parties is from, none of the arbitrators, apologies, is from Korea or from the US. This seems to make sense, but unless you do arbitration on a regular basis, you would not know what significant consequences this can have in practice, where you significantly limit your pool of arbitrators that is available, and then finally end up in a situation where you cannot pick the person you would really have wanted to pick, and potentially, again, satellite litigation. This brings us to our last topic for today's webinar. Unfortunately, we do not have more time, so only 3 topics. The last topic is procedural tweaks. Now, we highlighted the clauses as such, multi-tiered dispute resolution clauses. We highlighted requirements for arbitrators. And the last topic is procedural tweaks. To those of you listening in who regularly do arbitration, you will have certainly seen clauses where the parties significantly alter a standard clause, and they put in various additional requirements or rules, such as there shall not be any document production. But that's just one example. it is, again, a free world, and thus it's up to the parties on what to agree. However, is it always a good idea to agree on so much, or would also less sometimes be more? Shireen, I hand over to you.
Thank you, Harald. So, when parties make procedural tweaks to an arbitration clause, they often do it obviously with good intentions. And, as Mino was saying, it's usually the corporate colleagues, and it's usually that 5 p.m. Friday night when the disputes team gets a call and says, can you just cast your eye over this quick clause? We're about to sign the contract. And it's all wrong because, of course, it's not been drafted by the right people. But, so we understand that the intention is right, but then they're seeking to tailor the process to their needs. But this can lead to significant risks, a lot of which we've just spoken about. One is the unintended path to litigation, because overly complicating pre-arbitration steps, such as multi-tier processes or mandatory negotiation, can lead to disputes about whether these steps were actually properly followed. And what does that lead to? That leads to delay in the arbitration itself and costs. The second risk that I see is enforceability and a challenge to enforceability. Because if you're adding specific qualifications for arbitrators, you're limiting not only the pool of arbitrators, but you're making it difficult to constitute a tribunal. And that can open the door to the challenge that have you actually appointed the right arbitrator for what was specified. The other thing is a conflict with institutional rules. So, custom making those procedural tweaks can inadvertently contradict or complicate the application of arbitral rules, leading to confusion and inefficiency. Another risk that I see is jurisdictional uncertainty. So you could have vague or inconsistent wording, particularly if it's drafted by people who don't understand arbitration. And if you have vague or inconsistent wording, it can give rise to jurisdictional issues, with one party arguing that the arbitration clause is defective or does not apply. The other risk is it could just become an unworkable clause because it's over-engineered, and in practical circumstances, it's unworkable, and again, leading to a procedural battle rather than an efficient resolution to the dispute. I sit on the LCIA board, and by virtue of sitting on the board, I can tell you that each revision to the rules that are made takes a lot of time, takes a lot of experience, takes a lot of discussion, and takes a lot of thought. So there's a lot of thought that goes into creating those institutional rules. So why not just follow it and keep it as simple as possible? So my key takeaway and my conclusion is precision matters, but actually simplicity is key.
Fantastic. Thank you so much, Sherina. So a lot can go wrong in your experience. We don't have much time, so I'll limit my comments for now. I hand over directly to Mino. What are your views and your experience, both positive and negative?
I agree with what Sherina has laid out with us. That being said, I would like to also share a ray of optimism to this round of talk. Not everything is always going wrong. And if something goes wrong, good for the dispute law, as the audience might think. I had a case where the parties had agreed in the arbitration agreement to have the time period for the arbitration limited to 6 months from the start of the arbitration until the issuance of the award, with a possible 3-month extension as per the party's choice, which the parties have chosen to do. So it was a 9-month period. It was a USD X billion-dollar dispute. It was not a small one, but it concerned a very time-sensitive industry. It was a pharma industry, I can disclose that. Such that developing something and rendering a decision on a certain dispute was quite time-sensitive. guess what? It worked. A lot of people were working on that case and required a lot of focus, a lot of attention. And the tribunal members were all willing to abide by this timeline when they were accepting their appointments. And voila, it worked. And so I got to self-reflect after this dispute that sometimes we self-restrain ourselves a bit too much, thinking this is not possible, but in fact it is. And so not advocating for this for every contract, for every dispute, but there might be certain time-sensitive industries or time-sensitive contracts in which certain tweaks or variations might actually work out well. So it really depends on how the mutual need, I would say, from the parties in that transaction. I'll pause here.
Thanks a lot, Mino, also for your spreading of some optimism here. maybe your clause, the one you were dealing with, was amended by not only someone from the industry, but also someone with experience in arbitration who realized that this could work out. But of course, it could be an outlier, and in your case, it worked out, and otherwise it would not have. And indeed, you clearly highlighted the dangers. Christine, you have the honor and opportunity to share your views on this at the very end. What is your experience with tweaking with the arbitration procedure, and what should parties do, what should parties not do?
Thank you, Harald. I think Sherina and Mino have covered the two sides very well, so I don't think I have a lot to supplement.
You need to mediate between those views, Christine.
Yeah, I congrats Mino for that 6 months workout. It's really great. And but again, I'm a little bit conservative towards what Sherina has expressed. I think at the drafting stage, when you draft a contract, you don't know what will happen, and it's kind of difficult to put in some procedure tweaks. But you also just leave it a little bit room and the flexibility, and in the process you can tweak it out. You can add something, you can reach agreement to counsel. Maybe that's more pragmatic and flexible to work out.
I'm reminded by Christine why we need 6 eyes, not 2.
Sure.
Indeed. Thank you so much, Christine, for this sort of summary at the end. If I may quickly summarize those points, Sherina highlighted the Friday afternoon 5 p.m. clauses. Indeed, I think this was also optimistic, right? We often refer to arbitration clauses as midnight clauses. So Friday afternoon 5 p.m. may indeed be a very civil time. But no, on a serious note, if you mess with the arbitration clause, if I may put it so colloquially, if you make changes here, make changes there, you may really cause a big mess rather than streamlining something that you intended. And indeed, there was also the notion of over-engineering. So I think what we have to keep in mind here is that the rules of institutions out there, and let's stick with the ICDR, the people who design their rules, who draft the rules, they very well know what they are doing. So you can generally start from the assumption that unless there are special circumstances, unless there are special considerations, if you do not change anything, you are still in safe hands. You do not need to reinvent the wheel, because the ICDR rules are a very, very solid, robust, and very well-drafted set of rules that will definitely get you from the starting point towards the end. However, I also wish to emphasize the optimism that Mino spread with us today. where he highlighted that in a special case where there was special needs by the parties because of the specific industry we were in, tweaking with the time limits worked with all the disclaimers and notes of caution that Mino made. We have 5 minutes left here. I would like to quickly check with each of our panelists and ask them for one final piece of advice when it comes to getting it right from the start with drafting arbitration agreements. Because yeah, we have some time left, and I think that's a good opportunity to end this first webinar of this new series on. So who would like to start with his or her #1 tip on drafting arbitration agreements? Christine, you are the first to raise your finger, so
okay,
let's start with you, please.
Yeah, just start. Yeah, very briefly, I think drafting arbitration clause is kind of laying the railway tracks for the train to run on. So it's really fundamental and very important and deserve a lot of thoughts for the parties, you know, about various elements, and really avoid the 5 minutes to midnight to do this dispute resolution, and consult not only the corporate lawyer, but also dispute resolution lawyer about that.
That's an excellent tip. Thank you so much, Christine. Who is going next? I see no finger.
I'm happy to.
Mino, please go ahead.
In a typical dispute resolution clause, you have to choose 3 elements. Which rules are we going to put in? What's the seat of arbitration? And the third one is, strictly speaking, not part of the dispute resolution clause, but it's considered at that stage in parallel with what governing law are we going to put in. In my experience, the first 2, which is the rules and the seat of arbitration, are quite often synced. And so if it's not a must, you don't have to choose Singapore for SIAC and Seoul for KCAB and so on, but quite often they are synced, such that if you can choose that combination, that set, if you like, go for the set with the same regional rules and the relevant seat, because they have been tested, and it's less risky.
Thank you very much, Mino. And on that note, as I suppose everyone knows, but just to remind everyone, the ICDR obviously does have an office in various parts of the world, including in Singapore, here in Asia. So you can absolutely sync that. Sherina, you have the last word.
Well, you know, Mino and Christine have said pretty much everything I was going to say, but I would say my takeaway is, when drafting an arbitration clause, always consider the end game, where enforcement will take place and where the assets are going to be located, so that your choice of arbitral seat aligns strategically with enforcement and feasibility.
Thank you so much, Sherina. Also an excellent point. Of course, you do not want the arbitral award to not be worth the paper it's written on. You want to enforce it. And that plays a key role, and that's a crucial consideration which the parties should take early on. It is 4:59 in Singapore, so let me take this to thank all 3 panelists so much for their great insights, their great war stories, which I'm sure we all will remember, and also their very specific advice, which is probably harder to remember because it's not as plastic as the war stories, but which I hope still every one of you out there takes away. I take this opportunity to again remind you that this is just the initial session of a whole series. So please do follow the ICDR on including LinkedIn, and subscribe to its mailing list so that you stay informed. Once again, thank you very much to my three wonderful panelists. If this were in person, I would ask for a round of applause, but I give you a virtual round of applause. And I thank everyone for tuning in. Thank you so much and have a wonderful rest of the day.
Thank you, Harald. Thank you. It's
Thank
very
you.
enjoyable.
Thank you very much.